Thomas Thompson.
Okay.
We've prepared a notebook that we haven't actually prepared yet for your Honor's convenience and a notice of appearance and copies of all exhibits shown to opposing counsel. May I approach?
You may. Have y'all seen these?
Yes.
Okay.
Your Honor, we have a few housekeeping items that we would like to address at this time, as well as a substantive motion that my co-counsel will address in a moment.
All right, let's get introductions over here and then we'll jump into that.
Good afternoon, Your Honor. I'm Clair, sir.
And I'm Colin Spengler. Collectively, we represent the plaintiff in this case, Madeline Fortenberry.
Okay.
Additionally, Your Honor, we have a few housekeeping matters before substantive motions.
Okay. I'm gonna let the plaintiff proceed, or y'all are plaintiff, so I'm gonna let you go first, and then we'll jump in.
Your Honor, I'd like to inquire as to where to place exhibits as they become entered into evidence.
Put them up here.
I'd also like to confirm that any and all objections will be heard constructively outside the presence of the jury,
Yes, they will.
and that witnesses have been constructively sworn.
Any objection to that?
No objection.
Okay.
I'd also like to confirm that time will be stopped for all objections.
It will.
And, Your Honor, the exhibits have been pre-marked for identification purposes. We ask that these exhibits retain their markings for the court's convenience.
Any objection to that?
No
All
objection.
right, they will retain their markings, identify them as you need to.
And Your Honor, we'd like to bring to the court's attention that you have previously ruled that this case is bifurcated, and today's trial is purely about negligence. There will be no evidence presented about damages.
Okay.
And additionally, Your Honor, you've already ruled that a violation of a statute is not negligence per se, and thus it cannot be argued that solely the violation of a statute is negligence in this trial.
Any issue with that?
No, Your Honor.
Okay.
And finally, Your Honor, we have a notice of appearance from yourself.
Go ahead.
And with that, that is all of our housekeeping matters. We also have some substantive motions.
Any other housekeeping issues?
Yes, Your Honor, I would just like to confirm that we have the freedom to move about the well.
Yes.
Thank you.
We're not gonna ask that.
Yes, Your Honor. Before proceeding to trial, the plaintiff has two substantive matters we'd like to bring to the court's attention.
Okay.
By way of context for those motions, today's case involves a claim of negligence brought by Madeline Fortenberry on behalf of her late husband, Zeke. Today you'll learn that her husband, Zeke, lost his life in an airplane crash that took place on the defendant's property while Zeke Fortenberry was trying to land on a runway that was owned and operated by the defendant. Our first motion involves Exhibit 1, which can be found in the trial materials, which you have a copy of. Would you like us to approach and provide a copy of Exhibit 1, Your Honor?
No. Just tell me about it.
Exhibit 1 is a report prepared by the National Transportation Safety Board that details that organization's investigation into this crash. It's an expert report that gives opinions and conclusions as to the cause of this crash. Today, we do not anticipate the defendant to call any witnesses that participated in the making of this report, the drawing of the conclusions listed in this report, and therefore, we do not anticipate the defendant to be able to lay any of the necessary foundation under Rule 702 for this report to be admitted into evidence as an exhibit. Although we have stipulated that this document is not hearsay, we have not waived any other objection to this document at this time. We argue that they will be unable to lay the proper foundation under Rule 702, and this exhibit should not be entered into evidence here today.
Any response?
Yes, Your Honor. Opposing counsel's motion is brought underneath a case Goldberg v. Kelly, which says that you have the right to cross-examine adverse witnesses even outside of criminal cases. However, this case, not only was it decided in 1970, it also actually holds that you have a right to cross-examine adverse witnesses where administrative actions are under scrutiny. There are no administrative actions under scrutiny here today, and so we do not believe that this necessarily applies. We do not anticipate using Exhibit 1, but in the case that it does need to come in, we believe that it is still admissible. As opposing counsel has said, it is not hearsay, and we have no reason to believe that the information contained therein is anything other than reliable.
What about that?
Your Honor, a careful reading of Goldberg v. Kelly tells the court that the U.S. Supreme Court held in that case that any time a determination rests on a question of fact, the right to cross-examine adverse witnesses is an essential part of due process. Here today, in addition to being unable to lay the foundation under 702, the defense will not be calling the author of this report, the person who made these conclusions, and therefore the plaintiff would not be able to cross-examine that witness as to the reliability or credibility of those conclusions. Therefore, in addition to being unable to lay the 702 foundation, it would violate a due process concern that was addressed by the court in Goldberg v. Kelly.
Anything else?
Your Honor, I stand by my argument. This case held that due process and the right to cross adverse witnesses is normally for criminal cases, and this exception is for administrative actions that are under scrutiny, and therefore is not applicable today.
But the fact that you could have taken the depositions of various NTSB agents to figure out who wrote it and what their opinions were.
Your Honor, that information was not provided to us in discovery as the authors of this report.
But you had the report.
We do have the report, Your Honor, and if I could turn Your Honor's attention to it, there are no authors even listed on this document.
Sure, but couldn't you have sent a subpoena to the NTSB to find out who authored it?
Yes, Your Honor, we surely could have.
I'm gonna hold that in abeyance for now. You can raise the issue later if you need to, but I'm not gonna exclude it at this time.
Yes, Your Honor. The second motion the plaintiff would like to bring to the court's attention, the defendant, we anticipate today, will contest several elements of the negligence claim. Specifically, we anticipate the defendant will contest whether a duty actually existed. Courts have consistently held that the question of whether a duty exists is solely a question of law that can only be decided by a judge. That's never a question of fact that can be decided by a jury. In this case, given that we are on the eve of impaneling a jury to decide the question of fact in this case, it is clear that the court and the judge has ruled that in this case a duty does exist and has ruled in favor of the plaintiff on that matter. We request that defense counsel and defense witnesses be prohibited from presenting any evidence contesting whether a duty existed. That's not to say that information as to what duty existed can't be presented, but by way of contesting whether a duty existed, that evidence should be prohibited here today.
Okay. What about that?
Your Honor, we do not anticipate bringing any evidence to contest that Mr. Thompson owed a duty. However, we do anticipate that there will be questions as to whether or not Mr. Fortenberry was a rightful recipient of that duty. Should that come at issue today, we believe that we should be allowed to present evidence and let the jury determine the matter of fact as to whether or not that duty is extended to Mr. Fortenberry.
What about that?
Your Honor, if I may turn your attention to the jury instructions in this case, there's no question posed to the jury in those instructions regarding whether a duty exists or not. That's not a question that is properly submitted to the jury here today. It's clear that this has been ruled upon. It's a matter of law that a duty does exist.
Your Honor, just as the jury instructions are silent on duty, the record is silent on duty as well. We have nothing to show us that the matter of whether or not a duty was owed or has been established has been litigated prior to this point.
I'm gonna overrule that objection and let them, if they intend to challenge it, they're certainly entitled to challenge it. We'll take it up at mid-trial if we need to relate it to the legal aspect of that at mid-trial.
Yes, Your Honor, and with that, the plaintiff is ready to proceed.
Right? Anything from the defense?
Yes, Your Honor. We would just like to elaborate and bring to the court's attention that, as opposing counsel has said, this trial is bifurcated, and as such, we ask that any evidence regarding Mr. Thompson's wealth be excluded from testimony here today. We believe that a matter of Mr. Thompson's wealth, when damages are not at issue, would only serve to confuse the jury and to prejudice the case against Mr. Thompson and his potential resources, rather than whether or not there's a factual determination of negligence.
Okay.
Your Honor, today's case, the allegation of negligence is that the defendant was negligent in properly and adequately maintaining the runway on his property. As a part of maintenance, the question must be asked whether Mr. Thompson could finance that maintenance, whether he had the means to actually perform maintenance on that runway. For the purpose of showing that he had the means to hire individuals to come out and fix that runway, to perform repairs on that runway, the question of his wealth and his means should be able to be presented to the jury here today to frame whether his actions actually were reasonable.
Anything else on that?
Yes, Your Honor. We have no issue with evidence being presented to whether Mr. Thompson was capable of paying for the repairs that are necessary. We simply ask that any evidence regarding any excessive wealth be excluded in order to prevent any prejudice towards Mr. Thompson.
I tend to agree with that. But if it goes to whether he could fix it or not, or if costs, if that's the testimony that it was too expensive or whatever, then certainly it's relevant. So I will overrule that, but make the objection again if you need to.
Thank you, Your Honor.
Anything else?
Your Honor, the defense is ready to proceed.
All right, you may, plaintiff, you may give your opening statement.
May it please the court?
Yes.
At 11:22 p.m. on August 18th of 2013, an air traffic controller's calm night is interrupted. It's interrupted by a desperate call, a call from pilot Zeke Fortenberry. Zeke Fortenberry needs to make an emergency landing, and he needs to make that landing right now. Together they find a runway with lights that give Zeke one shot at landing safely. One shot at making it home to his wife, Madeline. But today you will learn that those lights never came on, that the actions of the defendant turned Mr. Fortenberry's one shot at safety, his one shot at making it home to his wife, into nothing more than a shot in the dark. I'm Clair Hollingsworth, and I, along with my co-counsel, Colin Spangler, represent the plaintiff, Madeline Fortenberry. Madeline could never have known that her husband's favorite hobby would have taken some role in his death. That the last conversation they would ever have was before he got into his plane. That every plan they had ever made was never going to happen. On August 18th of 2013, Zeke Fortenberry began a flight from Missouri to Lone Star. During that flight, he encountered engine failure, and he needed to make an emergency landing. He contacted air traffic controller Alex Bell, and they found a runway where Zeke Fortenberry could land, a runway with lights, a runway at South Fork Ranch. Now, these lights are called a Pilot Activated Lighting System, a PAL system, and it means that the pilot can turn on the lights from his plane by clicking his microphone a certain number of times. Then a radio receiver on the ground hears the clicks and turns on the lights. As soon as Zeke realized that this runway had a PAL system, he began to click over and over and over again, trying to turn those lights on so that he could land safely. Now, as he was circling South Fork Ranch, trying to turn the lights on, clicking furiously, nothing was happening. He was losing altitude, he was losing speed, and he was losing hope. The defendant, Thomas Thompson, knew something that Zeke Fortenberry didn't, and it was that those lights didn't work. That no matter how many times Zeke clicked and clicked and clicked, those lights were never coming on. Members of the jury, today's case is a civil case, which means you have to answer two questions. First, was Mr. Thompson negligent? And second, what role did that negligence play in the death of Zeke Fortenberry? Now, to answer these questions, you'll need to understand what negligence means. At the end of today's trial, the judge will come before you and tell you that negligence means the failure to use ordinary care. So that means today we must prove that the defendant failed to use ordinary care, and that his failure to use ordinary care led to the death of Zeke Fortenberry. And we must do this by preponderance of the evidence, which means we must prove to you that it is more likely than not that the defendant's actions were the cause of Zeke Fortenberry's death. To help you answer these questions and to determine if Mr. Thompson was negligent, we'll bring you two witnesses. First, you'll hear from Alex Bell. Now, Alex Bell is the air traffic controller that was with Zeke Fortenberry in his final moments. Alex Bell will tell you that Zeke was trying to turn those lights on over and over again. Alex Bell will tell you that Zeke needed those lights because this was an unfamiliar runway, because this was a dark Lone Star night. And Alex Bell will tell you that those lights, they never came on. Next, you will hear from Sam Williams. Sam Williams is a mechanical engineer with expertise in accident reconstruction. Now, Sam Williams will be able to tell you exactly what a PAL system is and how it works. And Sam Williams will tell you that Mr. Thompson applied for and accepted federal funding to build this PAL system, and that with that funding came rules that Mr. Thompson had to follow. Rules that said if those lights don't work, you need to fix them. Now, Sam Williams will tell you that on August 10th, Mr. Thompson found out that there was something wrong with those lights. And Sam Williams will tell you that it was the radio receiver, the part on the ground that hears the clicks and turns the lights on, that wasn't working. And that Mr. Thompson could have and should have had that radio receiver fixed before August 18th, when Zeke Fortenberry was trying to make that emergency landing. Members of the jury, today I want you to remember 3 things during the course of this trial. First, that Mr. Thompson failed to shoulder the responsibility. That Mr. Thompson failed to obtain the repairs. And that Mr. Thompson failed to spread the word. Now let's go through those a little bit more. When Mr. Thompson accepted that federal grant, when he accepted that responsibility and agreed to follow the rules that said if the lights don't work, you have to fix them, he shouldered that responsibility. But when he found out on August 10th that those lights weren't working, he did not shoulder the responsibility, and he failed to be responsible. Second, Mr. Thompson failed to obtain the repairs. You will hear that when he found out that those lights weren't working on August 10th, he didn't try to go down there and fix it. He didn't call anyone to come fix it. He didn't order any parts. He didn't make any repairs. All he did was send one email. One email to his ranch manager that said that, hey, these lights aren't working. But nowhere in that email did it tell him to fix it. Members of the jury, you will also find out that Mr. Thompson failed to spread the word. When he found out that the lights weren't working, he didn't call the FAA like a reasonable person. He didn't call air traffic control letting them know, don't route pilots to my runway, these lights don't work. He didn't call anyone. You'll find out that the only people that knew that those lights weren't working were Mr. Thompson, his runway manager, and the friends who had tried to use the lights when they hadn't turned on. At the end of today's trial, when you remember those things, when you see that Mr. Thompson did fail to shoulder the responsibility, that he did fail to obtain the repairs, and that he failed to spread the word, we are confident that you will see those actions turn Zeke Fortenberry's one shot at safety, his one shot at making it home to his wife, into nothing more than a shot in the dark. Ask Mr. Thompson to take responsibility by finding him liable at the end of today's trial. Thank you.
Defense.
May it please the court. Take command. Take command of your life, of your actions, of your fate. Commanding your life means having responsibility. Commanding your life means taking care of things as every ordinary person needs to do, as every ordinary person is expected to do, and as each one of us, as ordinary people, is required to do. And what you're going to hear today, members of the jury, is how Mr. Thompson took command of everything that he was required to do. My name is Christy Torres, and I, along with my co-counsel Madeline Dukes, represent Mr. Thomas Thompson in the case before you today. Now, as plaintiff's counsel already mentioned, today you're going to hear a tragedy about an accident that occurred on Mr. Thompson's property. See, the pilot, Mr. Fortenberry, was attempting to fly nonstop from Kansas City to Dallas, a 480-mile journey. But unfortunately for Mr. Fortenberry, mid-flight, his plane lost all power. And that was because, well, he ran out of fuel. You see, you're going to learn in a little bit that the aircraft Mr. Fortenberry was flying didn't even have the fuel capacity to get him safely to his destination in accordance with the Federal Aviation Administration's rules. So, from the moment he took off in Kansas City, Mr. Fortenberry was never going to make it to Dallas. And And unfortunately, Mr. Fortenberry was ultimately unsuccessful in landing his fuelless aircraft. And today's case is about who is responsible for that fatal accident. It was not Mr. Thompson. Mr. Thompson owns a property called South Fork Ranch. And on South Fork Ranch, he installed a private runway. He also installed something called a pilot activated lighting system on this runway, a PAL system for short. You see, what a PAL system does is it allows a pilot from the air to turn on the runway lights. In a little while, you'll hear that no one is required to have a PAL system. It's simply a matter of choice. And Mr. Thompson decided that he wanted to have a PAL system on his runway because he and his friends like to land their planes at night. And having this lighting system simply made it safer for them to do so. Now, even though Mr. Thompson took this safety precaution, he and his friends rarely actually used this PAL system. They merely called Mr. Thompson's ranch manager to turn the lights on for them. Everyone always called the ranch manager. Now, Mr. Thompson received some federal grant money to help him install this PAL system, and you're going to hear all about this today because they came with some guidelines. And see, the lights weren't working on the night of Mr. Fortenberry's crash. We don't dispute that. But what we do dispute is that Mr. Thompson did something wrong in his maintenance of those lights. And what we do dispute is that because these lights weren't working, that caused Mr. Fortenberry's crash. Now, while you're listening to all of this information today, we want you to remember something very important. Who took command of their situation in all of the ways they were required to do? Now, at the end of the day, the judge is going to instruct you on the law, but I, just as plaintiff's counsel did, want to talk to you about it just briefly. See, today's case is a negligence case, and that means that someone failed to use ordinary care. And the plaintiff today has the burden in proving to you that Mr. Thompson failed to use ordinary care. And they have this burden based on a preponderance of the evidence, which means more likely than not. Think about the scales of justice. So before anyone came up here to talk to you today, these scales were completely even. Now, as the attorneys come up to you and talk, and as you hear testimony and as you see physical evidence, the weight will begin to weigh on the scales. This side is plaintiff and this side is defense. And whichever side is weighed down by evidence, even by a fraction, at the end of the day must prevail. And we're convinced that the weight of the evidence will side with us. Now, the plaintiff is alleging that Mr. Thompson is the reason for Mr. Fortenberry's death. And in a few moments, they're going to come up here and present to you their side of the story. We anticipate they will call 2 witnesses today. One of them, Alex Bell, was the air traffic controller on duty the night of the accident. Ms. Bell was at the end of a 17-hour shift when she answered the plaintiff's emergency call. She also gave Mr. Fortenberry inaccurate information while Mr. Fortenberry was in the midst of this emergency crash landing. Next, we anticipate that the plaintiff will call Sam Williams, a professional in aircraft reconstruction. Mr. Williams looked at the information in this case, and he's going to try to convince you that Mr. Thompson's at fault. But remember, Mr. Fortenberry's plane was never going to make it to Dallas, and that was not the fault of Mr. Thompson. Next, Ms. Dukes and I are going to come back up here and present to you Mr. Thompson's account of the accident. First, you're going to hear from Kim Bates, a professional in the field of aircraft accident investigation. And Ms. Bates is going to reiterate to you 2 important things. First, that Mr. Fortenberry did not take command of his flight. And second, Mr. Thompson did everything he was required to do once he realized his lighting system wasn't working. And last but not least, you're going to get to hear from Mr. Thompson himself. He's going to tell you that he did everything he was required to do in getting his light system fixed. So throughout today, we want you to focus on one thing. Who took command? Every time you hear a new piece of evidence, ask yourself that question. And the answer to that question is not going to be Mr. Fortenberry. The answer is going to be Mr. Thompson. Mr. Thompson took command. And once you have all the pieces of evidence and you put them on the scales of justice, you will see that you will have to find Mr. Thompson not liable. Thank you.
Okay. Call your first witness, plaintiff.
Plaintiff calls Alex Bell to the stand. Can you please introduce yourself to the court?
Yes, my name is Alex Bell.
What do you do, Ms. Bell?
I am air traffic control for the Federal Aviation Administration.
Have you had any related jobs?
I have. I worked as an avionics design coordinator and with the National Transportation Safety Board.
Where were you working on August 18th of 2013?
As an air traffic controller for the Federal Aviation Administration, the FAA.
What time did you go into work that morning?
That morning I arrived at 7 a.m.
How long was your shift going to be that day?
I was working my regular shift until 4, but then I also was covering for a friend, so that went until midnight.
Do you normally cover shifts for friends?
Oh yeah, all the time. You know, I try and help out the people I work with day in and day out.
Do you think that covering shifts affects your ability to work?
Oh no, not at all.
Why are you here today?
I was the air traffic controller the night that Mr. Zeke Fortenberry called in, and I was the person that he spoke to.
How did he call in?
He called in through his radio to try and find some help from us.
Are these conversations recorded?
They are.
How are they recorded?
Every time a pilot is in trouble and calls into the station, it automatically records every conversation.
Is there any other recording of this conversation that would be more accurate?
No, just the actual recording, and then they also make transcripts of all of them.
Have you seen this transcript before?
I have,
Would having this transcript aid you in your testimony today?
definitely.
Your Honor, may I approach the witness with what's been marked as Exhibit 9, showing a copy to opposing counsel?
May.
Ms. Bell, what is this document?
This is the transcript of the interaction between me and Mr. Zeke Fortenberry.
And is that a fair and accurate copy of that document?
It is.
Your Honor, at this time, the plaintiff offers Exhibit 9 as evidence.
Any objection?
No objection, Your Honor.
Without objection, Exhibit 9 will be entered into evidence.
Ms. Bell, looking at this transcript, is this similar to conversations you have with other pilots in emergencies?
It is. We are taught, protocol, and I followed that here.
What do you do when pilots call in with emergencies?
Well, we talk to them and try and figure out what the problem is, and just try and help them solve that problem.
Why did Mr. Fortenberry call in on August 18th?
Oh, well, his first comment was that he had lost power to his plane and that he couldn't restart its engine.
Were you eventually able to locate Mr. Fortenberry?
No. I was.
Was he able to tell you his altitude and his speed?
He was. He told me exactly what his altitude was and his speed, which was 3,000 feet originally, and that he was going 80 knots.
Were there any public runways where you could direct him?
No, I couldn't find any public runways, but he eventually found a private one that I also located.
What runway was that?
That was the runway at South Fork Ranch, pardon me.
Where was that runway?
South Fork Ranch.
How far away was that runway from Mr. Fortenberry?
It was about 10 miles from him.
What did you know about this runway?
I just knew that it was a private runway and that it had a PAL lighting system.
Was there any information that you had about whether this system worked or not?
No.
What is a PAL system?
A PAL system is a runway lighting system that allows pilots to basically turn the lights on themselves. So when they're coming in, they send in clicks, which is in a microphone. So they click onto their microphone via the radio, and it's supposed to turn the lights on.
Was Mr. Fortenberry clicking his microphone to turn the lights on?
He was.
While he was clicking, was he losing altitude?
He was. He dropped significantly in altitude and in speed.
So while he was clicking, trying to turn these lights on, was this becoming an emergency situation?
Definitely. It was extremely dark that night. There was no moon, and he wasn't familiar with the area, so him not being able to see anything that's going on nor know about it, and then losing speed and altitude, it was a pretty dire emergency.
What was your last contact with Mr. Fortenberry?
I just basically wished him luck in landing and hoped for the best.
What did he say?
He didn't respond after that, and I tried to get him to speak to me a couple of times. When he didn't respond, I called it into my supervisor.
To your knowledge, did he eventually crash?
He did.
To your knowledge, did the lights ever turn on?
They did not.
Thank you, nothing further this time.
Any cross exam?
Yes, Your Honor. Ms. Bell, you work for air traffic control, right?
I do.
And you were working on the night of Mr. Fortenberry's accident,
I was.
and he called in to air traffic control?
He did.
Now, he called in to air traffic control at the end of your shift, right?
Yes, correct. It was a little after 11, or a little before midnight, actually.
So it was about the last 45 minutes of your shift.
Mm-hmm.
And that was at the end of a 17-hour shift?
Correct.
Now, Mr. Fortenberry called in because he had an emergency, right?
Yeah, that's typically why we get calls.
And that emergency was because he ran out of fuel?
No, that's not what he told me. He told me that he had lost power and that he couldn't restart his engine.
Thank you, Ms. Bell. But I'm just asking, I'm not asking exactly what Mr. Fortenberry told you. I'm just saying his emergency was that he ran out of fuel, right?
I don't know. He didn't tell me that.
Ms. Bell, the NTSB created an investigation report, right?
Yes, I'm sure they did. They do that with all accidents.
And you reviewed that report, right?
I might have. I'm not sure. I don't remember.
Would you remember giving a statement in this case, Ms. Bell?
I would.
And would seeing that statement help refresh your memory?
I have it here if you want to direct me to the line.
I beg the court's indulgence. So, on page 7 of your statement,
Mm-hmm.
line 7,
Mm-hmm.
do you want to read that and then we can start again?
Sure, you can go ahead. I've read it.
Okay, so did you review the NTSB report?
I did, briefly.
And one of the reasons for Mr. Fortenberry's crash was because the aircraft lost engine power due to insufficient fuel?
That is what the NTSB.
Objection, Your Honor, hearsay?
Hearsay. What is your response?
It's stipulated, Your Honor, in this case that the NTSB report is not hearsay.
Okay. Have you stipulated that it is not hearsay?
We have, but if they want to ask Ms. Bell to testify about it, they should enter it into evidence.
Well, you've stipulated to it, then I don't know what the problem is, so. Do you want to enter into evidence this time, or do you want to just
I
question?
don't want to enter
Okay.
it into evidence at
I'm
this
gonna
time.
overrule the objection then, and she can question her about it as she feels she needs to.
Thank you, Your Honor. Ms. Bell, so Mr. Fortenberry had insufficient fuel, right?
That is what the conclusion from the investigator was in the packet that I briefly reviewed, yeah.
So that means he didn't have enough fuel for his entire trip, right?
I'm guessing that's what running out of fuel means.
And that's bad, right?
I would assume so.
Because it caused Mr. Fortenberry's aircraft to lose all
Objection, Your
power.
Honor, lack of personal knowledge.
What's your response to that?
Your Honor, Ms. Bell has personal knowledge as to this. She was the air traffic controller that was on the phone with Mr. Fortenberry during his emergency. She is the only one who has knowledge about the exact incident of this accident.
Go.
Your Honor, she's not an expert in this incident, and the only information that Ms. Bell has is the information included in the transcript. There's nothing about fuel in this transcript, and thus she cannot give an opinion about the causes of Mr. Fortenberry's crash or the amount of fuel that Mr. Fortenberry had or anything of that nature. She's not an expert.
I'm not asking that, Your Honor. I am simply asking if running out of fuel is bad.
Overruled.
So, Ms. Bell, because Mr. Fortenberry ran out of fuel, he had to land his plane, right?
Yeah, he tried to land his plane because he ran out of fuel.
And he had to land right then and right there.
Well, he got to the, when he ran out of fuel, he was still in the air. He got pretty far to the actual area of the landing strip and tried to land there. He couldn't because of lighting.
When a pilot runs out of fuel, they have to land their plane, right?
Ideally, as soon as possible.
As soon as possible. And you tried to help him, right?
Yep.
But to help him, you needed to be able to see his plane on your radar, right?
Well, he was able to communicate where he was with me, and then I found him.
But it's most beneficial for you to see the plane actually on the radar, right?
I mean, if I know where he is, I can do the same amount of help as knowing it one way or another. It's still just knowledge.
But you had to actually ask him to turn his transponder on, right?
Oh, yeah, and he did.
And that was because you couldn't see him on your radar, right?
Originally.
And transponders are important so that air traffic controllers such as yourself can see where that plane is flying, right?
Yeah.
So next, Mr. Fortenberry told you that he was looking at his iPad,
Mm-hmm.
and he was looking at his iPad while he was flying.
That seems to be what he was doing. I wasn't in the cockpit, but that seems to be the case.
And so while he was looking at his iPad, while he was flying, on one of his apps, he found a private airfield, right?
Yep, and then I was able to also find it and help guide him to it.
Okay, and so he asked you what it was,
Mhm.
right? And you told him it was South Fork Ranch, right?
Yes,
And you also told him that South Fork Ranch had a pilot-activated lighting system on it, right?
I did.
And generally, these lighting systems use either a 3, a 5, or a 7-click system, right?
That's correct.
And South Fork Ranch use a 7-click system, right?
Yes, I do believe that's correct.
And you told Mr. Fortenberry it used a 3-click system, right?
Initially, I did tell him that.
Nothing further, Your Honor. Thank you.
Any redirect?
Briefly. Ms. Bell, if Mr. Fortenberry clicked 7 times, would those lights have come on?
No, they were broken, so they weren't going to come on regardless.
Thank you, nothing further.
All right, witness may stack down. Does the plaintiff have any other witnesses it wishes to call?
Yes, Your Honor, the plaintiff now calls Sam Williams. If I may approach and tender Exhibit 9.
Okay.
I really smell the shoes, I'm sorry.
We all do.
It's a good thing.
You may proceed.
Can you please introduce yourself to the members of the jury?
My name is Sam Williams.
Mr. Williams, what do you do for a living?
I am a mechanical engineer with an accident reconstruction consulting practice.
You said you reconstruct accidents. Specifically, what were you hired to do in this case?
I was specifically hired by you to reconstruct the accident of the airplane crashing onto the runway without the lights turned
Now, before we get into that investigation, it's important that the members of the jury get a chance to hear about your background. Tell us a little bit about where you went to school.
Well, I went to college out at Texas Technical and Agricultural College to get a degree in animal husbandry with a minor in mechanical engineering, and I soon just fell in love with mechanical engineering. I loved it. So I went on to get my master's degree in it from Rice University over in Houston.
And where have you worked?
Well, I went to a private consulting firm whose business was designing highways, bridges, and airport runways. And then I was there for about a decade, 10 years. And then I hired on with a private consulting firm that did accident reconstruction and investigation. And I stayed there for about another 10 years. And then I went out on my own as a consultant in the field of accident investigation.
You said you're a consultant in the field of accident investigation. What types of accidents do you investigate?
Specifically, I investigate aircraft accidents involving landings on runways.
Now, in this case, without going into any specifics, were you able to reach a conclusion as to the cause of the crash on South Fork Ranch?
Yes, I was.
In reaching that conclusion, did you have sufficient information on which to rely?
Yes, I did.
And was that investigation based on reliable principles and methods that are used in your field?
Yes, it is.
And are your conclusions in this case drawn to the degree of certainty that's used in your field?
Yes.
Your Honor, at this time, the plaintiff moves to qualify Mr. Williams as an expert in the field of accident investigation.
Any objection?
No objection, Your
All
Honor.
right, without objection, Mr. Williams will be qualified as an expert in the field of accident investigation. You may proceed.
Mr. Williams, you said you reached a conclusion as to the cause of this crash. What was that conclusion?
It is my expert opinion that Mr. Thompson had a duty to properly maintain the runway lights on his private runway if he was going to have a pilot-assisted lighting system installed on that runway, and not doing so was reckless.
Now, you just mentioned a runway. Did you go look at that runway at South Fork Ranch?
Yes, I did.
Your Honor, I'm showing opposing counsel what has been marked as Plaintiff's Exhibit 6.
Okay.
May I approach the witness?
You may.
Mr. Williams, can you tell the members of the jury what that document is?
You handed me a picture of Mr. Thompson's runway at the ranch.
Is that a fair and accurate depiction of that runway?
Yes, it is.
Has it been changed or altered in any way?
No, it has not.
Your Honor, at this time, the plaintiff moves to enter Plaintiff's Exhibit 6 into evidence.
Any objection?
One moment, Your Honor. No objection, Your Honor.
All right, without objection, Exhibit 6 will be entered.
Mr. Williams, if you wouldn't mind just turning to the member of the jury and tell where on this photograph is this pilot-activated lighting system?
The PAL, or pilot activated lighting system, is going to be located right down here in the bottom right. You see where that light is? It's going to be a little radio transponder right there.
And what role does that radio transponder play in that lighting system?
Oh, it's a very critical role. See, when the pilot is starting to descent to come to the runway, they click the button on their headset, and that transmits down to this radio operating system, turns it on.
If that radio receiver is broken, what happens?
Oh, the light simply won't turn on.
You can put the picture down, Mr. Williams. You said in this case something was wrong with that system. Were you able to determine what actually was wrong with it?
Yes, upon my investigation, I determined that the PAL system on the runway was not operable.
And what specific piece was inoperable?
Specifically, it was the receiver for the radio that would beam down and get the signal from the pilot.
And you said that runway is located on South Fork Ranch. Who was responsible for the maintenance of that runway?
Mr. Thompson would have been responsible for that maintenance.
How did you learn that?
Well, it's given in the FAA regulations. If you're going to have one of those, you have to maintain it.
Your Honor, I'm showing opposing counsel what has been marked as Plaintiff's Exhibit 8. Mr. Williams, can you tell us what that document is?
This is the FAA's regulations about maintenance and repairs for the PAL systems.
Is that a true and accurate copy of those regulations?
Yes, it is.
Has it been changed or altered in any way?
No, it has not.
Your Honor, at this time, the plaintiff moves to enter Plaintiff's Exhibit 8 into evidence.
Any objection?
No objection, Your Honor.
Without objection, Exhibit 8 will be entered into evidence.
You said these are FAA rules. Can you explain what role they played in your investigation?
Well, you certainly look to these during an investigation because these are the standards that somebody who has the system has to live up to when using that system.
What types of airports do those rules apply to?
Both private and public. LAX has to follow it, and Mr. Thompson would have to follow this.
And what do those rules specifically say about maintenance and repair?
If you look down here at 3.3.2, that's the section of the regulation, it says, if the lighting system fails to perform as designed, the operator shall undertake all necessary repairs.
Now, in this case, you said the lighting system was not operational. What could have been done to maintain or repair it consistent with those rules?
Two things. First, Mr. Thompson could have actually repaired it, gone out and made sure that the radio receiver worked, or could have alerted the FAA that it wasn't working to give him some time in order for him to repair it.
They said the first thing he could have done was go out there and fix the lights. How long would that have taken?
Not very long at all. 10 days, roughly. Less than 10 days. I'm sorry. Less than 10 days.
And you said that he should have notified the FAA. He should have notified someone. Who should he have notified?
The FAA, he should have spread the word so that nobody tried to land on a runway that was not working properly.
Now, during your investigation, did you find any evidence of Mr. Thompson's knowledge that those lights weren't working?
Yes, I did. I found an email that showed he had knowledge that they weren't working.
Here I'm showing opposing counsel what has been marked as Plaintiff's Exhibit 12. Mr. Thompson, can you explain to the members of the jury what that is?
This is an email between one of Mr. Thompson's neighbors and Mr. Thompson alerting him that the lights were not working.
Who is that email sent by?
It was sent by Mr. Barrett, who
Mr. Williams, if I could just focus you to the top of that and the to line, or the
Oh.
from lines, who's the author of that email?
C.B. Thomas. Oh, from the from. I'm sorry, Mr. Thompson.
The defendant?
Yes. Sorry, I got mixed up there.
Your Honor, is that a true and accurate copy of that email?
Yes, it is.
Your Honor, at this time, the plaintiff moves to enter Plaintiff's Exhibit 12 into evidence.
Any objection?
No objection.
Without objection, Exhibit 12 will be entered into evidence.
Now, what role did that email play in your investigation?
This was a pretty critical one because this told me that he actually knew the lights weren't working. And since I got out there and nothing had been done to repair the operation and the FAA didn't know about it, this showed me that he didn't take the necessary steps to start repairing it.
And what date was that email sent on?
It was sent on Saturday, August 10th, 2013.
Now, Mr. Williams, you talked a lot about the runway on South Fork Ranch. Did you also look into the weather conditions that night?
Yes, I did.
And what did you learn about those conditions?
When looking into the weather conditions, I noticed that they were visible. So it should have been very easy for him to see while flying.
Your Honor, I'm showing opposing counsel what has been marked as Plaintiff's Exhibit 10. Mr. Williams, can you tell the members of the jury what that is?
Yes, this is a National Oceanic and Atmospheric Administration weather report.
Is that a true and accurate copy of the report that you looked at during your investigation?
Yes, it is.
Has it been changed or altered in any way?
No, it has not.
Your Honor, at this time, the plaintiff moves to enter Plaintiff's Exhibit 10 into evidence.
Any objection?
No objection, Your Honor.
No.
Pursuant to substantive stipulation 4, we've agreed this is admissible under
Okay.
Item 3.
Without objection, pursuant to stipulation, it will be admitted then.
Mr. Williams, you said that the visibility was clear that night. Can you read off the first line of that NOAA forecast?
Yes, it says information for VFR flight at 5,000 feet, MCI to DFW.
What does VFR mean?
Simply put, it means that there are going to be visible flight conditions when they're up flying.
Now, did you actually get to take a look at the crash site during your investigation?
Yes.
Your Honor, I'm showing opposing counsel what has been marked as Plaintiff's Exhibit 5. Mr. Williams, is that a photograph? Can you tell the members of the jury what I just handed you?
He handed me a photograph of the crashed airplane.
Okay.
Is that a fair and accurate representation of that crash site?
Yes, it is.
Has that photograph been changed or altered in any way?
No, it has not.
Your Honor, at this time, the plaintiff moves to enter Plaintiff's Exhibit 5 into evidence.
Okay. Any objection to that?
Yes, Your Honor, we believe that this should be excluded under Rule 403.
Okay. What is your response to the Rule 403 argument?
Your Honor, in order for evidence to be excluded under Rule 403, the probative value of it must be substantially outweighed by the danger of unfair prejudice. If I could turn Your Honor's attention to the actual photograph, that's just a photograph of the plane and the crash site. At the point that photograph was taken, the pilot's body had been removed. That photograph does not show the body of the pilot, any gruesome images, blood or gore. In that case, this photograph is probative in today's case because it corroborates the testimony the witnesses are going to hear about the crash site itself, about the airplane Zeke Fortenberry was flying. And really this photograph is the only insight we have as to what happened visually that night. And a photograph of the crash scene corroborates that information.
Anything else from the defense on that?
No, Your Honor.
Okay. Then I'm going to overrule that objection, and it can be entered into evidence this time.
Mr. Williams, what does that photograph tell you?
It obviously tells me that he couldn't see the runway and missed it by a long shot.
What could have been done to avoid that crash?
Well, two things. The lights could have been repaired so that the lights lit up and he could have landed properly. Or Mr. Thompson, could have alerted the FAA so that nobody attempted them.
All right, thank you. No further questions at this time, Your Honor. If I may approach and retrieve the exhibits and tender them to the bench.
Certainly. Any cross-exam of this witness?
Yes, Your Honor. One moment, please. May it please the Court?
Yes, go ahead.
Now, Mr. Williams, you are a mechanical engineer, correct?
Yes.
And in college you studied animal husbandry, right?
Well, that's only one of my degrees, but
Right. You then went on to get a master's in mechanical engineering, right?
pretty significant degree, yeah.
And then after college you went into designing bridges and runways, right?
Yeah.
And then you came into the field of accident reconstruction, correct?
Yeah, I think your timeline's right there.
And then that's what brought you to today's case, right?
Accident reconstruction?
Yes.
Yeah, I like doing that. It's interesting.
And you're paid $500 an hour to do that, right?
Yeah.
And in doing your job for today's case, you reviewed several things, right?
Yes, I did.
Part of that was the FAA regulations, correct?
Correct.
And those regulations pertain to the maintenance and repair of runways, right?
Yes, that's true.
And in those regulations, it says that an airport operator has to repair a runway in a reasonable amount of time, right?
Yes.
But those regulations don't give us any guidelines as to what reasonable is, do they?
No, I don't believe so.
They don't give us any examples.
Nope.
They don't give us any explicit timeline.
No.
But you have an opinion as to what timeline is reasonable to have repairs made, correct?
Of course.
And your opinion is that 10 days is a reasonable amount of time, right?
It could have been done in under 10 days.
But your opinion is that 10 days is reasonable, correct?
Correct.
Now, you also have an opinion that Mr. Fortenberry was reasonable in the accident, correct?
Yes, certainly.
That he did everything he could have done.
Yes.
However, he still let his plane run out of fuel, didn't he?
I mean, I don't know if you purposely told the airplane to run out of fuel.
But the plane ran out of fuel, correct?
Yeah, yes.
And you also reviewed FAA regulations as to what pilots are supposed to do, right?
Yes.
And a pilot is responsible for making sure his plane is fueled correctly, aren't they?
Yes.
And part of making sure your plane is fueled correctly is doing the calculations, right?
Yes, certainly.
And the calculations take into account things like trip distance and the weather reports and the conditions that the pilot will face when encountering his flight, right?
Yes.
And in checking the weather report, one of the main things a pilot should check for is wind, right?
Certainly.
And there are headwinds and tailwinds and ground winds. All of these are different things, right?
Yep.
And all of these winds can affect the amount of power a pilot uses and the amount of fuel a plane will use while he's flying, correct?
Correct.
And Mr. Fortenberry only checked the local weather report, right?
It's still a weather report that gives him the wind readings that you're talking about, that shows some visibility. So, yeah, certainly it was local, but it still conveys the same information. In fact, if it's local and locally defined there, I mean, it gives
Right.
great information.
And it does tell us the winds. It tells us the winds. It tells us the ground winds, right?
Mm-hmm.
But Mr. Fortenberry wasn't on the ground, was he?
I mean, at one point he was, but
Well,
no.
I mean, he was on the ground when he landed. So those winds would tell us whether or not he needed a jacket. They wouldn't tell us whether or not he was going to encounter severe winds along the path, correct?
Sure.
And there are weather reports, though, that will give us a more indicative wind capacity. They will tell us things other than the ground wind, right?
Yeah, I guess so.
And the NOAA report is an example of this, right?
The NOAA report, yes.
And the NOAA report on the night in question, it told us that the winds and Mr. Fortenberry's flight were going to be 25 to 28 miles per hour, right?
Are you referring to the NOAA report that the other lawyer guy showed me?
Yes.
Can I see that report? Possible.
May I approach?
You may.
Thank you.
No problem. Just take a moment.
Okay, could you repeat your question? I'm sorry.
Yes, that NOAA report tells us that the winds in question were 25 to 28 miles per hour, right?
Well, let me just first start off by saying one thing, and then yes, I'll get to your answer. The time stamp on this NOAA report would have been zero use to him because he would have already been in the air. Winds, I'm not a meteorologist, but winds constantly change here and there. So certainly this report that you've given me, yes, tells me about the winds in the air, but the time stamp on it signifies to me he would not have known about those winds because when he took off, those winds might not have been in existence.
That's correct. But this type of report does tell us what the winds he would have been, what sorts of winds he would have encountered, correct?
Yes, a report like this would tell you that.
And Mr. Fortenberry would have had access to a report like this had he looked for it, right?
Yes.
And the 25 to 28 miles per hour, that's quite a bit more than the 10 miles per hour projected by the local weather report, right?
Not a meteorologist, but yeah, I think so.
So the difference in that wind capacity or wind speed would have severely affected the amount of power the plane used, right?
Not a meteorologist, but yes, I would imagine so.
Well, I want to talk a little bit more about the regulations that a pilot has to follow. You've reviewed those, correct?
Yes, I have.
And those are fuel regulations as well, right?
Certainly.
And these require anyone flying an airplane to comply with those regulations, right?
Yes.
And I don't have a whiteboard. I should have done that. I'm going to pretend like I have a whiteboard. So part of that fuel regulations in it is that it requires a pilot to have enough fuel to get from point A to point B, right?
Yes.
But then it also requires a pilot to have enough fuel to get another 45 minutes, right?
Objection, Your Honor, that's evidence rule violation. The attorney is testifying to and questioning the witness about the contents of a document, and the most accurate copy of that document can be entered here in court today.
What is your response?
Your Honor, we have no problem introducing this, these regulations if that's what opposing counsel would like.
Go ahead.
Now, Mr. Williams, you said you reviewed these regulations, right?
Yes.
So would you recognize them if I showed them to you?
Yes.
Your Honor, I'm showing opposing counsel what's been marked as Exhibit 7. May I approach?
No.
I'm showing you these fuel requirements, Exhibit 7. Now, if you'll take a moment to look over those and refresh your memory.
Okay.
So, to continue, they require a pilot to have enough fuel to get from point A to point B, wherever his destination is, and then another 45 minutes worth of fuel, correct?
Correct.
Objection, Your Honor, relevance. If I may be heard,
Okay.
these rules apply to a specific type of flight, and the witness has previously testified that the flight that Zeke Fortenberry was taking is not consistent with the type of flight that those rules talk about. Therefore, those rules are inapplicable to the flight Zeke Fortenberry was taking.
Your Honor, we have never testified or asked any sort of questions about what type of flight Mr. Fortenberry was taking that night, if it was any sort of classification that would prohibit or make these rules inapplicable.
What else?
Your Honor, the witness previously testified that this was considered a VFR flight. VFR is terminology used by the FAA, and that is substantiated by evidence that has been presented and entered into the record here today. These rules do not apply to those VFR flights. These apply to a completely different type of flight. And if I may proffer outside the presence of the jury, no evidence will be presented here today that these rules actually apply to Zeke Fortenberry's flight. That his flight was considered an IFR flight.
What about that?
Your Honor, I would say that I do not believe there has been any evidence sufficient to establish the difference between a VFR flight and an IFR flight, and that Mr. Fortenberry was determinatively in either one of those categories. And even if that's the case, we still have a right to cross-examine on that and to challenge that issue, and part of that is bringing in those fuel regulations. If the type of flight he was encountering did meet one of these classifications, and we believe that it meets the other one, then we should be able to introduce evidence as to such. He'll have an opportunity to redirect and declare.
Do you intend to call a witness that would testify it was an IFR flight condition?
Yes, Your
All
Honor.
right, then I'm gonna overrule that objection, and you can proceed.
Yes, Your Honor.
We'll try this one more time. So, those regulations require a pilot to have enough fuel to get from where he's going, or where he is to where he's going, and then another 45 minutes, right?
During an IFR condition flight, yes.
And this amount of fuel is required before the pilot takes off, right?
During an IFR condition flight, yes.
And Mr. Fortenberry's flight, IFR condition or not, was 480 miles, right?
Yes.
And I want you to assume that there's no wind at all, that we're working in a vacuum and that there's nothing adverse affecting Mr. Fortenberry. Can you do that for me?
Yes.
Now, Mr. Fortenberry's plane was capable of going 120 miles per hour, right?
Mm-hmm.
So 480 miles, it would have taken him 4 hours to get from point A to point B, correct?
Correct.
And the fuel consumption for this trip would have been 40 gallons, right?
Correct.
Now, Mr. Fortenberry also needed that extra 45 minutes, right?
Based on the IFR condition regulation you put in front of me, yes.
So for that 4 hours, he needed 40 gallons, then he needs another 3/4 of an hour, then he needs another 7.5 gallons, right?
Yes.
So even before takeoff, he needed 47.5 gallons of fuel, correct?
For an IFR condition flight, yes.
But the Piper Cygnet only has a usable fuel capacity of 45 gallons, right?
Yeah, that is true.
So Mr. Fortenberry could have never been in compliance with these regulations because his plane was not capable of holding 47.5 gallons of fuel, right?
During an IFR condition flight, you're absolutely right, but during a VFR condition flight, which the no report shows, you're wrong.
Well, but back up with me here for a second. Mr. Fortenberry could have never been in compliance with those regulations, could he?
These ones you put in front of me for IFR conditions, yes, you're right.
Now, I want to touch on one last point with you. Opposing counsel has gone over what could have prevented Mr. Fortenberry from being in this position, correct?
Correct.
And you testified that if the lights had been on or if Mr. Thompson had called FAA, that we could have prevented this, right?
Yeah, definitely. That would be the best way to go about that.
Could this flight have, or could this accident have also been prevented if Mr. Thompson had, or Mr. Fortenberry had not run out of fuel?
In my expert opinion, I think fuel always helps. Fuel is always a great thing when you're in the air, but the lights are the most important here.
But bear with me, yes or no, this flight could have been prevented if Mr. Fortenberry had never run out of fuel.
Yes.
No further questions.
Any redirect?
Now, Mr. Williams, Ms. Dukes was asking about those rules. Can you read out the title of those FAA rules?
Section 167, fuel requirements for flight in IFR conditions.
What does that title mean?
That means that these are the required legal standards for flight during non-visibility conditions.
Now, what information did you find during your investigation that this was an IFR flight, like those rules say?
I found nothing that signified that.
What evidence to the contrary did you find?
I found from the NOAA report that it was a VFR flight.
If this was indeed a VFR flight, would those rules apply?
No, they would not. These are for IFR flights.
All right, thank you, Your Honor. No further questions.
All right, witness may step down. Does the defense or plaintiff have any witnesses it wishes to call?
No, Your Honor, the plaintiff rests.
All right, any motions we need to take up at mid-trial?
Yes, Your Honor, at this point, the defense moves for judgment as a matter of law. We believe that the plaintiffs have failed to prove any breach of duty by the defendant, and that even their own expert has testified that 10 days would have been a reasonable amount of time to complete any repairs, and the accident in question only took place 8 days afterwards.
Okay, what do you say?
Your Honor, we believe that we have proved that there was a duty and that a reasonable juror would find so. The expert that she was referring to testified that a 10-day limit would be reasonable if those repairs were started. At the 8th day, those repairs still had not been started. Thus, we proved that Mr. Thompson did indeed have a duty and did breach it.
Okay, I will deny that motion. Do we need to take a brief break? And then we need to take a break for that, right?
Yes,
Your Honor.
Call your first witness.
The defense calls Kim Bates. May it please the court.
Yes.
Please introduce yourself to the jury.
Hi, my name is Kim Bates.
Where do you live, Ms. Bates?
I live in Paris, Lone Star.
Tell us about your educational background.
Okay, well, I graduated high school in Athens, and then following high school graduation, I went to undergrad at Columbia, and I got a degree in philosophy. But that's not really a moneymaker, so I went back to school and I got my master's in aeronautical engineering at Tarleton University.
What is aeronautical engineering?
Basically, specifically studying the engineering of an aircraft. So it's a lot of math involved, a lot of aeroscience. So
Once you graduated from Tarleton University, where did you go to work?
I went to work in Fort Worth for a helicopter manufacturing outfit
How long did you work there?
for 12 years.
Where did you go once you left there?
After that, I opened a consulting engineering firm that specialized in consulting with aircraft manufacturers and their lawyers on matters in litigation.
Have you investigated accidents involving aircrafts?
Yes.
And what kinds of things do you look at when you perform an aircraft accident investigation?
Well, obviously we'll look at the aircraft, we'll look at the runway, the lighting system, just the surrounding area in general.
Have you ever been recognized in a court as an expert in aircraft accident investigation?
Yes, I have.
And has your expert testimony in that field ever been excluded?
No, ma'am.
Ms. Bates, what was your role in today's case?
Well, I was asked to look at the accident that happened at South Fork Ranch, and so I looked at all the depositions, the exhibits, and I reviewed the FAA's regulations, and things of that nature.
And did you use and apply reliable methods in your review of this case today?
Absolutely.
And without telling us what they are, were you able to come to any opinions based on those reliable methods?
Yes.
And would those opinions assist the jury in understanding what happened the night of August 18, 2013?
Yes.
Your Honor, at this time, the defense offers Ms. Bates as an expert in aircraft accident investigations.
Any objection?
Your Honor, the plaintiff would ask for permission to voir dire Ms. Bates regarding her qualifications prior to having her tendered as an expert.
Okay, go ahead.
Good evening, Ms. Bates. You said that you work as an aeronautical engineer, is that right?
Yes.
And you spent a good deal of your time working in a factory that actually manufactured airplanes.
Yes.
Now, fair to say, you've never worked on installing a PAL system, have you?
I haven't necessarily installed, but as an aeronautical engineer, it's common knowledge to know of PAL systems.
But you've never actually been involved with one personally, have you?
To install it, no.
You've never been involved with the maintenance of a PAL system, have you?
Well, do any kind of maintenance with aircraft, no.
You've never been involved with the repair of a PAL system?
No.
And in this case, you've never worked with the specific brand of PAL system that's at South Fork Ranch?
Like I said, I'm familiar with the PL systems, I understand how they work, but no.
But not the specific brand at South Fork Ranch?
No.
In fact, you never even went out to South Fork Ranch to look at that system?
I don't remember.
Your Honor, if I may approach opposing counsel with the witness's deposition.
Sure.
Ms. Bates, do you remember giving a deposition for this case?
Yes.
Now, you swore to the accuracy and the truth of everything in that deposition.
Yes.
This is a complete and accurate copy of that deposition.
Yes.
Now, can you please find in there where you talk about going to South Fork Ranch and actually looking at the PAL system?
Objection, Your Honor. Ms. Bates never said whether she did or did not go out to South Fork Ranch. She simply said that she didn't remember.
She did. Yeah. You need to refresh her if you need to. An impeachment is improper.
Thank you, Your Honor.
Sure. If you do, take a minute, Ms. Bates, and refresh your recollection regarding your travels out to South Fork Ranch.
Is there a specific line you want me to look at, or just?
Just take your time, Ms. Bates.
No.
So you would agree with me, you've never been to South Fork Ranch?
Correct.
You've never laid eyes on the PAL system at South Fork Ranch?
No.
Therefore, you have not drawn any conclusions based on your knowledge of that system?
No, I've drawn conclusions based on my knowledge, but not of, if you're saying that specific system, no.
So no conclusions based on the specific system at South Fork Ranch?
Correct.
All right, Your Honor, given the witness's testimony, we would object to having her entered as an expert in the field of accident investigation, and we would ask that her testimony be limited and should be barred from testifying about the PAL system at South Fork Ranch.
What do you have to say about that?
Your Honor, Ms. Bates doesn't need to know how to install, maintain, or repair this specific PAL system to testify for investigation. As an expert in investigation purposes, Ms. Bates stated that within her experience and knowledge of being an aircraft accident investigator, she has seen everything revolving around an aircraft accident, which includes these lighting systems, it includes runways. She does not specifically need to know how to piece one back together to be an expert in the investigation process.
Yeah, but isn't there a problem with the fact that she's going to give an opinion about the problems with this lighting system if she's never investigated one or seen one or?
Well, respectfully, Your Honor, she has investigated lighting systems before that, those are very common in aircraft accidents as a whole. She does have experience and knowledge of lighting systems and how they impact aircraft accidents.
What about that?
Your Honor, Rule 702 sets out a two-pronged test. The first prong regards the witness's actual training, knowledge, experience, or education. The witness has not testified as to any training, knowledge, experience, or education, or skill regarding the specific brand of pilot-activated lighting system at South Fork Ranch. Therefore, the first prong cannot be satisfied. Furthermore, the second prong, specifically the information she used during her investigation, the principles and methods, and the data that she used, she testified she'd never even been to that ranch. Therefore, she could not have had sufficient facts and data to rely upon. Therefore, under both prongs of Rule 702, she cannot be qualified as a witness to offer conclusions as to that system.
What about that?
Your Honor, I stand by my original argument that Ms. Bates has said she does have knowledge and experience with aircraft runway lighting systems. Additionally, the fact that she did not physically go out to South Fork Ranch to look at the system itself is inconsequential. She has done a fair and accurate review based on all of the documents that in this case. have no knowledge of what that brand is.
I'm gonna overrule that objection and cross-examine on those issues.
Thank you, Your Honor. Now, Ms. Bates, did you form an expert opinion based on Mr. Fortenberry's actions?
Yes, I did.
And what was that?
And that the accident was directly caused by the failure of Mr. Fortenberry as a pilot and in command of the aircraft to perform appropriate fuel calculations before undertaking his journey.
And are pilots supposed to make appropriate fuel calculations before they take off?
Yes, they are.
And who sets those fuel regulations?
The FAA.
Did you review a copy of their regulations in preparation for today's case?
Yes, I did.
Would you recognize them if I showed them to you?
Yes.
Your Honor, I'm now showing opposing counsel what has previously been marked as Exhibit 7. May I approach?
Yes.
Ms. Bates, can you tell us what I've just handed you?
Yes, this is the FAA's fuel requirements for flight in IFR conditions.
And do you recognize this document?
Yes.
Has it been changed or altered in any way?
No.
Did it assist you in coming to your conclusions for
Yeah.
today?
Yes. Sorry.
Your Honor, the defense offers Exhibit 7 into evidence at this time.
Any objection?
No objection, Your
All right, without objection, exhibit 7 will be entered into evidence.
Ms. Bates, could you please read Section A for us?
Yes. No person may operate a civil aircraft in IFR conditions unless it carries enough fuel, considering weather reports and forecasts and weather conditions, to 1, complete the flight to the first airport of intended landing, 2, except as provided in paragraph B of this section, fly from that airport to the alternate airport, and 3, fly after that for 45 minutes at normal cruising speed, or for helicopters, fly after that for 30 minutes at normal cruising speed.
So what exactly does that mean?
Basically, when a pilot is flying an aircraft, they have to have enough fuel for that journey plus another 45 minutes.
And how does a pilot calculate the fuel he needs?
So the pilot would need to know how much fuel the plane consumes per hour, and then how many hours it'll take to reach the destination.
Does weather also factor in?
Yes, and weather has a big impact on that as well.
How so?
Well, if there is a headwind, then it's going to cause the aircraft to move at a slower pace, therefore you'll need more fuel. And then if there's a tailwind, it's going to cause the plane to move faster, and so you'll need less fuel.
Did Mr. Fortenberry check the weather before he took off?
He did.
And what weather source did he use?
He used a local weather source. However, that's not a proper procedure. Usually, pilots are supposed to use the NOAA weather report.
Why is the NOAA report proper procedure?
Well, the NOAA report gives weather for in the air, whereas your local weather forecast is only on the ground, and so there's a disparity.
In what location did Mr. Fortenberry's local weather report give him?
It was for Dallas.
Now, was there a discrepancy in between the NOAA report and the local weather report for Mr. Fortenberry's flight?
Yes. The local report, I believe, had a tailwind, whereas the NOAA report had a headwind.
And to your knowledge, did Mr. Fortenberry ever look at the NOAA report?
No, not that I'm aware of.
Now, was Mr. Fortenberry carrying the appropriate amount of fuel for his trip?
No, he was not.
And how do you know that?
Well, in his aircraft, he had the wrong aircraft manual, and so because that was for a different aircraft, he would have taken or fueled the plane for the aircraft based off the manual.
So it was a miscalculation?
Yes.
Now, you said that Mr. Fortenberry didn't have the right manual in his airplane, right?
Correct.
How do you know this?
Well, the manual says the aircraft at the top, and that's not the aircraft he was flying. So.
And was that problematic for Mr. Fortenberry to have the wrong manual?
Absolutely. The manual that he had allowed or I wanna say it was, it said
Take your time, Ms. Bates.
okay. Yes, so the manual showed that the usable fuel capacity was 55 gallons, whereas the usable fuel capacity for the aircraft he was actually flying was 45.
And what aircraft was he actually flying?
He was flying, it was the Signet? I don't know if I'm saying that.
Now, Ms. Bates, who's responsible for the correct manual being in the aircraft?
That's the aircraft manufacturer.
Did you develop an expert opinion about the aircraft manufacturer in this case?
Yes, I did.
And what was that?
And that the accident was also caused by the fact that the aircraft manufacturer supplied the wrong owner's manual for the aircraft, leading the pilot to believe that he had more available fuel than he actually had.
Now, Ms. Bates, I want to talk to you about the pilot-activated lighting system on South Fork Ranch.
Okay.
Was Mr. Thompson required to have a lighting system on his ranch?
No, he wasn't.
And why did he have one?
Well, I'm assuming because you can get the government to fund it, and so.
So it's expensive to
Yes.
install a lighting system?
Yes.
And did Mr. Thompson receive federal grant money to pay for it?
Yes, he did.
Did federal grant money come with any guidelines?
Objection leading.
Rephrase your question.
Yes, Your Honor. Did the federal grant money have any restrictions around it?
Objection leading.
Rephrase your question.
Was Mr. Thompson subject to any rules or guidelines when he received this money?
There were just guidelines, but it wasn't like a standard rule, or it wasn't like a certain restriction on keeping the PL system like updated.
And do you remember what those guidelines said he had to do?
Yeah, basically they said that if you received the federal money to install the PAL system, that it was your responsibility to maintain the system as a reasonably prudent person would.
Is there anything in the guidelines that says what someone needs to do when the lighting system stops working?
No, there's no set timeline. I think, typically I would say anything under 30 days is appropriate if there's something wrong with your system.
And on the night of the accident, was Mr. Thompson's lighting system working?
No, it wasn't.
Did he know that?
There's reason to believe he knew it, but it's hard to say based off of what I've seen because it's not specific to what was wrong with the runway.
Did he do anything when he found out that it might not be working?
He inquired about it.
And how did he inquire about it?
He sent an email, basically asking about the expenses to get the runway fixed.
Was that the only email he sent?
That I'm aware of, I believe so.
I beg the court's indulgence. May I approach Your Honor?
Yes.
Ms. Bates, I am handing you what's already been entered as Exhibit 12. Take a minute to read through that. lighting system wasn't working?
Yes,
And how do you know that?
based off of this email.
And what is that email?
This is an email, from Tommy to Barrett about the runway lighting.
And when did he send that?
He sent this on Saturday, August 10th.
How many days prior to the accident was that?
8.
And was that a reasonable amount of time for the lighting system to not be working?
Absolutely.
And why is that?
Like I said, 30 days is probably a good amount of time from what I've seen for fixing runway issues, just because it's not a quick fix. So within 8 days is definitely reasonable.
Thank you, Ms. Bates. No further questions, Your Honor.
Cross-exam.
Your Honor, if I may approach and retrieve plaintiff's exhibit 10 that was entered into evidence.
Yes.
Let's see, maybe it's not there. There it is. Now, Ms. Bates, you said on direct examination that there were certain rules that Zeke Fortenberry had to follow. Is that right?
Correct.
And those rules, that's what made him have to carry that extra amount of fuel, the 45 minutes extra.
Yes.
Now, you would agree with me that you looked at a NOAA forecast during your investigation.
Yes.
Your Honor, may I approach the witness?
You may.
Ms. Bates, this has been entered into evidence as Exhibit 10. Is that the forecast that you looked at during this investigation?
Yes.
Now, you would agree with me that that forecast is the one that you said Zeke Fortenberry should have looked at.
Correct.
Now, all the information on there applies to his flight.
Yes.
Now, you would agree with me that the first line of that forecast, right up at the top, can you read that out for the members of the jury?
You
Right
mean
under the
right
NOAA logo. I believe
Okay.
it's in all capitals.
Information for VFR flight at 5,000 feet, MCI to DFW.
Now, Ms. Bates, you would agree with me that that means that this flight was classified as a VFR flight.
Correct.
Now, let's talk about those rules. Now, these rules, you would agree, only apply to flights in IFR conditions.
I would say that they apply to both.
Well, Ms. Bates, I might be missing. Can you show me on this document where VFR is mentioned in these rules?
It's not on the document.
Nowhere in this document, these rules, does it ever mention VFR.
No.
And you didn't bring any rules for VFR flights here today, did you?
Not specifically, no.
These rules would not have applied to Zeke Fortenberry's flight.
I believe that they do apply to his flight.
But you brought no evidence of that here today.
No.
Now, Ms. Bates, you said that you actually looked into the pilot-activated lighting system at South Fork Ranch. Is that right?
Correct.
But you would agree with me, you're not a mechanical engineer.
No, I'm not.
You're trained as an aeronautical engineer.
Yes.
You study how planes and their engines work.
I mean, that's a part of it, yes.
Well, that's what your degree is.
Yes.
Aerodynamics.
Yes.
But specifically, you've never worked with maintaining an airport runway.
No.
You've never worked in installing an airport runway.
No.
You've never worked in installing a pilot-activated lighting system.
No.
Now, in this case, you never even went out to South Fork Ranch to look at that runway, did you?
Well, I didn't need to go out to look at it. I had all the documents I needed, but no, I didn't.
But that's a no to my question, you never went out there.
No.
And you mentioned documents. You never got the maintenance records for the PAL system, did you?
No, I didn't.
You never got records that said each time it had been repaired.
No, but that's not necessary to still give my professional opinion.
Well, you gave an opinion about its maintenance, didn't you?
Generally, yes.
But you never looked at the times it was repaired.
No.
You never inquired as to how many times he had had to make service calls on that system.
No.
You never looked at how many times that system had broken before.
No.
Now, you said that in typical cases, it would take 30 days to fix a system like this.
Give or take.
But you would agree with me, you can't even tell the members of the jury here today what was wrong with that system.
No.
You can't tell them if a knob was turned in the wrong direction.
No.
Or if it was unplugged,
No.
or if a wire was loose?
No.
All right, thank you, Your Honor, no further questions.
All right, any redirect?
Yes, Your Honor, I just beg the court's indulgence for a moment. May it please the court.
Yes.
Ms. Bates, what type of documents do you typically have when you, or what do you typically do when you look into an aircraft accident?
I will look at the, like I said, the aircraft. I'll look at the PL system. I'll look at the runway. I'll look at any kind of exhibits that are provided, or depositions or interviews from people that are somewhat involved with the accident, and that all comes together to make my opinion.
Is it necessary for you to go out to the accident location to form your expert opinions?
No.
And Ms. Bates, did you have everything that you needed in this case to properly form your opinions?
Yes.
No further questions.
Okay. Witness may step down. Does the plaintiff or defendant have any other witnesses it wishes to call?
Yes, Your Honor, this time we call Thomas Thompson.
Your Honor, permission to retrieve the documents that have been entered into evidence?
Yes.
May it please the court?
Yes.
Please introduce yourself to the jury.
My name is Thomas Thompson. I go by T-Bone Thompson.
And what do you do for a living?
I own a chain of barbecue restaurants.
How long have you been doing that?
As long as I could work.
What do you do in your free time?
I just like to enjoy my ranch, be outside. And I also, I'm a pilot, so I like flying.
Now, tell me a little bit more about your ranch. How large is it?
The main part of the ranch is 1,000 feet, or 1,000 square feet, or acres. And then the annex to it is 40,000 acres.
So it's a pretty large ranch. Is there any special features on it? Does it have a runway?
It does have a runway.
What is
Pretty
this?
nice one.
What is it used for?
Well, I use it when I land if I'm flying, and also a lot of my friends fly, and so they land there too when they come to visit.
Mr. Thompson, is this the land where the accident occurred on August 18th?
It is.
How did you learn of that accident?
My ranch manager called me immediately and told me the news, and I was devastated by it.
What did you do when you found out?
I immediately went out there, went to go check on the situation, and I emailed the ranch manager and told him about it and asked him to fix it. Hold on a second.
Well, let's back up a little bit. We'll talk about your emailing the range manager in a little bit. But let's get back to your runway. Did your runway have any special equipment on it?
It had a lighting system, and it had the PAL capabilities for the lighting system.
And why did you have the PAL system specifically?
It was just an extra precaution because some of my friends would come in at night, and so I just wanted to make sure that if the ranch manager wasn't able to get out there, that they had a way to turn the lights on.
Did you ever use the PAL system yourself?
No, I didn't.
Why is that?
When I was flying, I always just called to my ranch manager, and he would go turn on the lights manually, and he'd have a car ready for me when I landed.
So, Mr. Thompson, do you ever land on the runway at night?
I do. I've done it a few times.
And do you have any experience flying?
I do. I'm a pilot.
And how was your PAL system funded?
Through a federal grant. I actually knew a vice president a couple terms ago.
And with that federal grant, did it come with any sort of rules or regulations that you had to follow?
It came with federal regulations that I had to follow.
And what did those regulations tell you?
They told me that they had to maintain certain standards, like having a lighting system on the runway.
And did you follow those rules?
Yes, I did.
And what did you do when you found out that the runway lights weren't working?
I immediately emailed my ranch manager and told him about the problem.
And
Stop
why?
saying that.
Sorry, I'd broken that habit. It's bad today. Sorry. Why did you do that?
Well, I wanted it fixed, and when I need something on the ranch fixed, I always talk to the field manager about it, and he gets it done.
Is Mr. Barrett qualified to handle those sorts of repairs?
Oh, definitely. He's been my field manager for a long time, and he always fixes anything that comes up on the ranch that needs fixing.
Now, do you and Mr. Barrett have a close relationship?
Yes.
Is it necessary for you to tell him explicitly, let's fix the runway?
No, he knows when I tell him that there's something wrong, he knows it's his role to fix it. And he always does.
I want to talk to you about one more email you sent. This is an email in July. You were talking about the runway expenses. Would you recognize that if I showed it to you?
Yes, I would.
Your Honor, I'm showing opposing counsel what's been marked as Exhibit 4. May I approach?
Yes.
Can you identify that for us?
Yes, this is the email that I sent to Mr. Thomas after I met with our CFO and saw the budget. And I just should I go into more detail?
No, that's fine. That's fine for now. Is this a fair and accurate copy of that email?
It is.
Has it been changed in any way?
No.
Your Honor, at this time, the defense would move Exhibit 4 into evidence.
Any objection?
Hearsay, Your Honor?
What is your response to that?
Your Honor, in response to their hearsay objection, this is a statement by a party opponent. We are their party opponent, and this would come into evidence as our own admission. I hate to use that on myself,
It
but
doesn't apply to you, so.
yeah, it's not hearsay. He has personal knowledge. He sent the email.
It's his email, right?
Right.
All right, overruled.
So,
Why are you
is the
objecting?
exhibit into evidence? I'd like to
Yes, it's
review-
in.
Okay.
Yeah, it's in.
Now, Mr. Thompson, what did you mean by there was too much money being spent on the property?
I just meant the budget looked like it had exceeded what I thought was necessary. It looked like there was a lot of miscellaneous charges, and I just wanted to make sure that we were taking stock of everything that was going on at the ranch, and that if there was any unnecessary spending, that we could cut it down.
Did you ever order any cuts on necessary spending?
No.
Would you ever tell anyone not to fix something in order to save money?
No.
No further questions, Your Honor.
Okay. Cross-exam?
Yes, Your Honor, brief moment to set up demonstrative. Mr. Thompson, you built a runway a couple years ago, right?
That's right.
And it cost a fair amount of money to build that runway.
A fair amount, but part of it was funded by the government, so that offsets some of the costs.
Right, so when you went to install the PAL system, you asked for federal funding.
Yes, kind of. It was a friend, the old vice president liked to come hunt on the land, so he wanted somewhere to land, and I think he told me about that I might be able to get some federal funds for it, so.
Okay, and with that federal funding you received, you had to agree to some rules, right?
That's right.
And these rules were mandatory.
That's right.
Now, before you agreed to these rules, you read them,
Mm-hmm.
and you understood them,
Sure.
and then you agreed to them, right?
That's right.
Now, you recognize these rules if you saw them today, wouldn't you?
Yes, sir.
Your Honor, may I approach the witness with what has already been entered into evidence?
Yes.
Mr. Thompson, those are the regulations you agreed to, aren't they?
Yes.
Now, Mr. Thompson, if you look with me at the very bottom of this page, under 3.32b, now the first sentence, it says that if the lighting system fails to perform as designed, the operator shall undertake all necessary repairs. Is that correct?
That's correct.
So that means when you know that the lights don't work, you have to fix them.
That's right.
And that means you have to undertake a repair. Now, if you look a little bit further in this section, it says that these repairs should be completed within a reasonable amount of time.
That's right.
Now, Mr. Thompson, let's talk about the repair that you undertook when you realized those lights weren't working.
Okay.
Now, on August 10th, you realized there was something wrong with the lights, right?
That's right.
Because a friend of yours had tried to use them and they hadn't turned on.
That's right.
Then you sent an email to your ranch manager, correct?
Correct.
And you recognize that email.
I would.
Now, Mr. Thompson, this is that email that you sent, right, on August 10th?
That's it.
Now, you just testified that when you sent an email, you told him to fix it, right?
I said I told him what the problem was, and
Okay.
he knew on his own that that meant to fix it.
But for the court, though, in this email, nowhere in this email does the word fix appear.
I don't say fix explicitly, but he knows if I tell him there's a problem on the ranch, he knows to fix it.
Okay, and nowhere in this email does the word repair appear.
No, but again, he knows what it means when I tell him there's a problem.
And it never says order the parts.
I wouldn't need to tell him to order the parts. He knows to do that on his own.
Now, Mr. Thompson, you never went down to the lights to try to fix them yourself, did you?
No, I didn't.
You never went down to look at them and see what was wrong?
No.
Because you sent this email to C.B. Thomas.
Right.
And when you send an email to C.B. Thomas to fix something, he fixes it.
That's right.
It always gets done.
Always does.
Will you explain to the court why 8 days after you sent this email, when Zeke Fortenberry died on your property, no parts had been ordered?
I assume he was still in the process of figuring it out. I don't know. I don't know what his process was for fixing a runway, but something that substantial of an undertaking to repair, I'm sure it took him time to figure out what parts he needed to order.
So you don't know, is what you're saying, correct?
I can't say specifically. I don't know what he was thinking.
And can you explain to the jury why 8 days after you sent this email, when Zeke Fortenberry died on your property, CB had not repaired those lights?
Again, it was a substantial undertaking. I would assume it's a big runway, so I think that would take time. And more than 8 days.
Mr. Thompson, you remember being deposed, don't you?
I do.
And you'd recognize that deposition if I showed it to you?
Yes, I would.
Your Honor, may I approach the witness with his deposition?
You may.
Mr. Thompson, this is your deposition, right?
Yes.
And this is your signature on this page, right?
Yes.
Now, Mr. Thompson, where in this deposition does it say that this was a large undertaking or that CB was working on fixing it?
I don't say that in the deposition. I don't. Oh, do I? Yeah, I don't say that. Sorry.
So, when you were asked to give a deposition about all the information you had regarding this incident, you didn't mention anything about this being a lofty endeavor, CB working on getting the parts, or about CB trying to fix it.
Well, again, that's not something that I would really take care of, so I would have left it to my ranch manager, and I don't know the specifics of it.
So you just really don't know what was going on?
I know what was going on. I told my ranch manager to fix it, and he was in the process of fixing it.
Well, let's move on. Mr. Thompson, when you realized that there was something wrong with the lights, you never called the FAA.
That's correct.
You never called air traffic control letting them know that those lights didn't work.
That's correct.
You never called any nearby airports letting them know not to route pilots to your runway because your lights didn't work.
That's correct. But I didn't think we needed to. It was only being used for me and my friends. We never, until now, had another person landing on it that wasn't someone I knew.
Mr. Thompson, you'd recognize a picture of your runway, wouldn't you?
I would.
Now, Mr. Thompson, this is your runway, isn't it?
Yes, that's a nice picture of it.
And so all these lights around it, this is the PAL system, right?
Yes.
Now, on August 10th, you realized that those lights didn't work, right? these lights over here to the right weren't working, right?
That's right.
And these lights over here to the left weren't working.
That's right.
None of the lights in this picture were working on August 10th.
Well, they were working, just not with the PAL system, right?
Right. So on August 18th, that PAL system still wasn't working, right?
That's correct.
And there's a little bit of daylight in this picture, isn't there?
There is.
Now you're aware that Zeke Fortenberry's crash happened in the middle of the night.
I'm aware.
And since the PAL system wasn't working, this is not what Mr. Fortenberry would have seen on August 18th when he was trying to land.
Yeah, it would have looked a little different.
It would have looked different because there wouldn't have been any lights on.
That's right.
Now, Mr. Thompson, you went out to look at the scene of the crash, didn't you?
Yes, I did.
Mr. Thompson, this is what you saw when you went to look at the scene of the crash.
That's right.
And someone died in this crash.
Unfortunately,
And that person was Zeke Fortenberry.
it was.
Nothing further, Your Honor.
Any regret?
Yes, Your Honor, briefly. Mr. Thompson, I want to talk to you about those regulations that opposing counsel just went over with you. Those regulations, what exactly were you required to do under those regulations?
We were required to have a working lighting system, which we had. The PAL system was just an added bonus that we happened to install.
Were there any actions you needed to take with the PAL system? What if it was broken?
We needed to fix it within a reasonable time, and we fixed it within a reasonable time.
Did those regulations ever give you any guidelines or examples as to what exactly was?
Objection, Your Honor, leading.
Rephrase.
What specific timeline do those regulations give you for those repairs?
They say it has to be fixed within a reasonable time. They don't say what reasonable is, and it didn't say immediately, it didn't say the next day, it just said reasonably. And for a runway of that size, reasonable is definitely 8 days at least.
What did you do when you learned the lighting system wasn't broken? Or wasn't working?
I emailed my ranch manager to have him fix it.
Did you believe that that was a reasonable action?
Yes, he always fixes any problems. When I email him and tell him something's broken, I don't need to say go fix it. He knows on his own. He's got to do what he needs to get it fixed, and he does.
How long has this been going on for you? Does Mr. Barrett usually get things fixed when you tell him to?
Every single time.
One last point I want to talk to you about. Under those rules, were you ever required to call anyone when something was broken?
No, there was nothing that said I had to call someone when it was broken.
No further questions, Your Honor.
All right, witness may step down. Does the defense have any other witnesses it wishes to call?
No, Your Honor.
All right.
May I approach and remove the exhibits?
Yep. Does the defense rest?
Yes, Your Honor, the defense does.
Okay. Any motions that we need to take up before closing argument?
Your Honor, at this time, the defense would like to renew our motion for judgment as a matter of law.
Okay. Denied. Ready to close?
Yes, Your Honor.
All right, let's do it.
Brief moment.
Oh, Madam, can I have my Thompson type of that?
I need the black. Dark red, a little bit black.
Yeah, we could just make it horrible. Is that any lighter?
May I
May I
proceed?
proceed?
Yes.
August 18th, 2013, 11:22 p.m. A quiet night is shadowed by a frantic call to air traffic control. Zeke Fortenberry has lost power in his airplane. He needs to make an emergency landing, and he needs to make that landing quickly. Now Zeke is directed to a runway that gives him a shot at landing his plane. A runway with a lighting system, lights that give him a shot at landing that plane safely. But today we learn those lights stayed dark when Zeke needed them most. That as Zeke clicked and clicked and clicked his microphone, desperately trying to turn them on, he saw nothing. Today we learned why. We learned that the defendant's actions turned Zeke Fortenberry's last shot at safety, his last shot at hope, into nothing more than a shot in the dark. Members of the jury, at the beginning of today's trial, Ms. Hollingsworth came before you and explained that we represent Madeline Fortenberry. She explained that today you learned that Ms. Fortenberry's husband, Zeke, tragically lost his life on a dark, lonely August night here in Lone Star. She explained that today's case all boils down to two very important questions. Whether the defendant was negligent in maintaining his runway, and if so, what role his negligence played in this crash. Now, you alone can answer those questions, members of the jury. In reaching your decision, it's important that you understand exactly what you're deciding on, exactly what the term negligence means, and why that term is so important here today. Now, as the judge will later instruct you, negligence is a failure to use ordinary care. A simple way of thinking about negligence is that a person can be negligent anytime they fail to do something we would expect a reasonable person to do. And as a result of those unreasonable actions, someone is injured, or someone loses their life. Now, members of the jury, I want you to keep that definition in mind as we talk about the facts, as we talk about the evidence that was presented today. Now, as we walk through that evidence, there are three things I want you to keep in mind. Mr. Thompson's failure to shoulder the responsibility he took on when he installed that lighting system. The defendant's failure to obtain the necessary repairs when he first learned that system wasn't working. And the defendant's failure to spread the word that those lights couldn't be relied upon. Now, members of the jury, let's first talk about the defendant's responsibility. We call this his duty. The reason why he had to maintain those lights. The reason why he had to repair them. Now, you may be asking yourselves why. If this runway was on his private property, if it was on his piece of land, why he should be responsible to anyone else, for anyone else. Why the government should be able to tell him what he can and cannot do with that runway. But members of the jury, today we learned a simple answer to that question. We learned that when Thomas Thompson built that runway and installed that lighting system, he took federal funds to do so. And when he took that federal money, he agreed to abide by certain rules. Rules that dealt with maintaining and repairing that system. Rules designed to keep pilots safe. Now, members of the jury, today you're going to get a chance to look at those rules. They're contained in this document, published by the U.S. Department of Transportation, that tell individuals who take federal money to install lighting systems exactly what they need to do, exactly how they need to maintain and repair those systems. Now, you're going to get to look at those rules, and there's one specific portion I want you to focus on. It says the repairs shall be undertaken, and that those repairs have to be completed within a reasonable amount of time. Members of the jury, you learned today that when Mr. Thompson took that federal money, he subjected himself to those rules. He agreed to abide by those rules. He agreed to shoulder the responsibility of maintaining that runway, of repairing those lights, of maintaining that lighting system. And he agreed agreed to maintain it in a reasonable manner. Now, members of the jury, we've heard this word reasonable used over and over and over again today. We heard the experts take the stand and tell you what they think is reasonable. We had Mr. Thompson take the stand and tell us that he doesn't really know what reasonable means. But that's okay. Because today you are the only people who can really decide what was reasonable. What actions the defendant should have reasonably been expected to take. What would have been reasonable for him to do? Now, members of the jury, today we heard about two separate and distinct actions that the defendant could and should have taken when he found out those lights weren't working. We first heard that he could have gone out there and fixed them. Today we heard exactly what was wrong with those lights. Sam Williams took the stand and testified that when he went out and looked at those lights, it was apparent what was wrong. The radio receiver was broken. Now, he told us that that system could have been repaired within 10 days. If Mr. Thompson had started trying to repair it on day 1, it could have been completed within 10 days. Well, what we learned is that on the 8th day, on the day Zeke Fortenberry needed that radio receiver to be fixed, on the day he needed those lights, no repairs had even been started. Over a week after learning that this system was broken, no parts had been ordered, no repairs had been made, nothing had been done. Now today the defense, they called a witness. Ms. Bates told you that she thinks it would take upwards of a month to fix those lights. But let's talk about what else Ms. Bates told you. She told you that she has no prior experience with the PAL system that was at South Fork Range. That she never even went out and looked at that runway, at that lighting system. She couldn't tell you what was wrong with it. She never laid eyes on the thing. But yet somehow today she sat here and tried to convince you that it typically takes 30 days or so. Members of the jury, typically is not what we're here for. We're here for answers. We're here for proof. And that is not what Kim Bates could tell you. All she could give us were guesses. But today we heard definitively from Sam Williams, from the plaintiff's expert, that those repairs should have been completed, should have been undertaken before Zeke Fortenberry lost his life. But when Mr. Thompson failed to obtain those repairs, when he did nothing for 8 long days, he failed to live up to the rules he agreed to. He failed to abide by those rules. He failed to shoulder the responsibility he took on. Now, members of the jury, even if you believe that that system was too complicated, it was too technical, that it just couldn't have been fixed by the time Zeke needed it, we heard about a second action that the defendant could and should have taken. We learned that he could have picked up his phone. He could have sent an email. He could have contacted the FAA, air traffic control, someone, anyone, to let them know that pilots shouldn't be directed to his range, that his lighting system was broken, and that pilots in emergencies couldn't rely on it. Now, in a moment, defense counsel will come before you and likely argue that nowhere in those rules, nowhere in the FAA rules does it say that Mr. Thompson had to contact someone when those lights were out. But that's where the definition of negligence becomes so important. Because nowhere in that definition does it say a person is only negligent when they break a rule. Nowhere does it say that a person is only negligent when they break the law. All that rule tells us, all the definition of negligence tells us, is that a person can be negligent when they fail to act reasonably. Now, members of the jury, many of us are fortunate enough to have never encountered Mr. Thompson's runway. We've never had to try to sit down a plane in a dark night. But that doesn't mean we've never faced danger. That doesn't mean we don't know what danger is. Now, all of us have been walking through the grocery store and walked down an aisle and seen one of those yellow signs standing up, saying, "Caution, wet floor. We know not to walk in that aisle because we put ourselves in danger. That sign puts us on notice that there's something dangerous ahead. We turn around. We go a different direction. We know not to go down that aisle because we've been given warning. But on the night of this crash, Zeke Fortenberry didn't know those lights weren't working. He was given no warning because Mr. Thompson failed to spread the word that those lights were out. He failed to let anyone know that those lights had stayed dark for 8 long days. Now, members of the jury, Zeke Fortenberry can't be here today to tell his story, to tell us what happened that night over South Fork Ranch. Instead, all we have are his words. Words contained in a transcript that you're going to get to look at back in the deliberation. Words that detail the last moments of his life. Now, from that transcript, we learn that Zeke ran into engine trouble. He needed to make an emergency landing. We learned that he was directed to South Fork Ranch. He was told South Fork Ranch had a lighting system that gave him a shot at landing his plane. There was a glimmer of hope in that cockpit. He thought he had a chance at making it. He was given that information. He was never told that those lights were broken and that they had stayed dark because Mr. Thompson failed to spread the word that they had been out, that he had not repaired them. Now, we learned what happened when Mr. Fortenberry arrived at South Fork Ranch. That as he scanned the horizon looking for that runway, he saw nothing. That as he clicked and clicked and clicked and clicked his microphone, nothing happened. As he looked back and forth, the night stayed dark. Today we learned why. We learned that no matter what Zeke Fortenberry did that night, those lights weren't coming on. Because Mr. Thompson failed to obtain the repairs that were necessary, to even undertake any repairs when he first learned those lights were broken. When Mr. Thompson failed to spread the word those lights were out, when he failed to obtain those repairs, he failed to shoulder the responsibility he took on when he installed that system. He failed to live up to the rules that he agreed to follow. Members of the jury, this is what Zeke was left with. This is what is detailed in that transcript of his call with Alex Bell. A distress call. A distress call that should have given him the information he needed to find a place to safely land his plane. To find a place to sit that plane down. But instead, he was never told those lights were broken because Mr. Thompson failed to spread the word they were out. No matter what he did, those lights weren't coming on because Mr. Thompson failed to obtain the necessary repairs. And we learned what happened shortly after. That his plane crashed and Zeke's life was taken from him. Because Mr. Thompson failed to shoulder the responsibility he took on when he installed that system. Members of the jury, this is what Zeke was left with that night. A dark night sky. Blackness. We learned today that the only lights that shone on South Fork Ranch that night were the lights of emergency vehicles pulling Zeke's body from the wreckage. It didn't have to end like this. Zeke should be here today. The defendant should have spread the word those lights were out. He should have obtained those repairs. He should have shouldered the responsibility he took on when he chose to accept that money, when he chose to put on those lights. Today we learned he did nothing. He failed to act. He failed to speak up. He failed to take command of the situation that he created when he put those lights there. This email, this is not taking command of the situation. This is passing the buck. This is pawning it off on someone else. But members of the jury, today you can't pawn it off on someone else. Today it's your responsibility to find the defendant liable for what happened that night. To find the defendant liable for turning Zeke Fortenberry's last shot at safety, his last shot at hope, into nothing more than a shot in the dark. Find the defendant liable for Zeke's death. Thank you.
Defense?
Your Honor, counsel, ladies and gentlemen of the jury, the plaintiff has just attempted to paint you this clear and vivid picture of what happened on the night of August 18th, 2013. However, the thing about pictures is that what might look clear and obvious to one person can look completely different to the next. Today, I am here to paint you a different picture. A picture that shows you a pilot that was never prepared for his flight and happened to land on the defendant's land. Ladies and gentlemen, we are here today because the plaintiff has attempted to prove that Mr. Thompson was negligent and thereby liable for Mr. Fortenberry's accident. Now, they explained to you that negligence is failure to do something that a reasonable person would do. However, when a reasonable person is given those rules and follows them, that's hardly negligent. The plaintiffs must have proven to you several things. That Mr. Thompson owed a duty, that he breached it, and that duty is what caused the accident. And they had to prove all of that to you by a preponderance of the evidence. Now, Ms. Torres came up here and told you today that a preponderance of the evidence was akin to the scales of justice, that they had to prove to you that this was more likely than not. And the plaintiff is on one side and the defendant is on the other. And these scales of justice started out even. Before today, they were even. But then each side began to present to you evidence. And it was the plaintiff's job to tip the scales in their favor. And that has not been done. They've not shown you that their evidence outweighs ours. That it is more likely that Mr. Thompson caused this accident than Mr. Fortenberry. We've heard this explained with the scales of justice and more likely than not, but this is not some simple seesaw. This needs to be less than a back and forth and clearly tipped in their favor. Because this burden is a gatekeeper before you can reach your verdict of liable. If they fail to tip the scales in their favor, then the proper verdict is not liable. And that's what we have here today. Now, the plaintiffs have told you that the evidence suggests that Mr. Thompson is to blame for the August 18th accident. And they've gotten up here today and told you all these things that Mr. Thompson should have done. But what they failed to talk to you about are the things that Mr. Fortenberry had to do. Now, we've seen the regulations that pilots have to follow in their fuel, in flying their planes, and the capacity that they needed. And we've seen from both expert witnesses today that Mr. Fortenberry was never in compliance with these rules. Mr. Fortenberry never bothered to check the weather that could have told him the correct wind information that would have changed his calculations. Mr. Fortenberry might have checked the wrong manual, but there was evidence to show that Mr. Fortenberry could have seen the right information on other parts of the plane. It was Mr. Fortenberry's responsibility to never take off unless he could reach his destination. And we've heard today that could have never been possible. Mr. Fortenberry was never going to make it to Dallas. Now, another thing we've heard today is that Mr. Thompson supposedly failed to complete these repairs within a reasonable amount of time. But the plaintiff's own expert witnesses told us that 10 days was a reasonable amount of time, and today we're looking at 8 days. The plaintiffs have failed to show you that Mr. Thompson did anything other than taking the reasonable precautions and undertaking necessary repairs. In fact, we've shown you that Mr. Thompson followed the regulations. He did everything a reasonable airport operator would have done in his circumstances. Now, I want to tell you my biggest fear for this case. My biggest fear is that you're going to let Mr. Thompson's role as an owner of a fancy runway with fancy equipment cloud your judgment. Should Mr. Thompson have fixed the PAL system? Absolutely. But that's not the only contributing factor here. First of all, the plane should have been fueled correctly. And more than that, a plane that could have had the right amount of fuel should have been flown. Had the plane not run out of fuel, Mr. Fortenberry never would have needed to make an emergency landing, and none of us would be here today. And as pilot of the plane, he was responsible for doing so correctly. Mr. Thompson was responsible for his own land, but his land would have never been needed if Mr. Fortenberry had not needed to make an emergency landing. It's as simple as that. With fuel, this would have never happened. And ladies and gentlemen, that is exactly why Mr. Thompson should not be held responsible for this accident. Whether or not he should have fixed the lighting system, and whether or not it would have been necessary, whether or not he should have fixed the lighting system that might not have even been necessary, and whether or not he's responsible for the death of an innocent man are two completely different issues, and they should be addressed as such, because it is your job to answer that later question. Is Mr. Thompson responsible and liable for the death of Zeke Fortenberry? Now, as you go into the deliberation room, I want you to remember that it was Mr. Thompson who followed every single rule given to him, and Mr. Fortenberry who never did. The evidence has overwhelmingly showed you today that Mr. Thompson is not responsible for the situation that led to Mr. Fortenberry's tragedy. And because of that, we ask you to find the defendant not liable. Thank you.
Rebuttal?
Now, members of the jury, defense counsel just came before you and did exactly what Mr. Thompson has been doing since August 18th of 2013. Pointing fingers, shifting the blame, doing anything that's necessary to blame someone else, anyone else, so that he doesn't have to take responsibility for what happened that night, so that he doesn't have to take responsibility for Zeke's death. Now, today the defense brought two documents in court today. Two documents that they rested their entire case on. We got to look at those. A forecast that they said Zeke should have looked at. A forecast the defense counsel said if Zeke had looked at, he would be here today. That he would not have needed to make an emergency landing. But what we learned is that this forecast wasn't created until Zeke Fortenberry was hundreds of miles into his trip. There was no way he could have accessed this forecast. He simply couldn't have. It didn't exist at the time he was preparing for his flight. It didn't exist at the time he took off. There was no way he could have accessed it. Now, defense counsel also talked again and again about these rules. But members of the jury, we heard today that these rules apply to a specific kind of flight, an IFR flight. What we learned today that Zeke Fortenberry's flight simply wasn't an IFR flight. It was a completely different kind. We learned that these rules, with the fuel requirements for carrying a little bit extra in case of emergencies, that requirement didn't apply to Zeke. These rules did not apply to him. We learned today that once we take those rules out, Zeke would have had enough fuel to reach his destination. He would have had enough fuel to make it there safely. But we learned that the unexpected happened. Wind shifted, weather changed. He needed to make an emergency landing. And he sought out South Fork Range. Now, we have to ask ourselves why defense counsel would bring these two documents into court today. A forecast that Zeke Fortenberry had no ability of looking at. Rules that didn't apply to him. Why would they bring these here? The answer is simple. They want to tell a specific story. They want to weave a specific tale that avoids Mr. Thompson, that points the blame somewhere else. anywhere else. I wanted to create distractions. Distractions to hide what Mr. Thompson did. But members of the jury, you can see through those distractions. You can see what the evidence told you happened. Now, defense counsel got up and started talking about painting pictures, but members of the jury, this is the only picture that matters. This is a picture that no one should ever have to paint. A picture that tells the story of a man who lost his life doing what he loved. Because the actions of another man, a man who failed to take responsibility, who failed to obtain the necessary repairs, and failed to spread the word that the lights were out, members of the jury, find Mr. Thompson liable for painting this picture, for causing this crash, for stealing Zeke's life.